a 13-judge bench, 68 days of arguments, and a razor-thin 7-6 verdict. That decided whether Indian democracy could one day be dismantled by its own parliament. This is Kesavananda Bharati versus State of Kerala, 1973, the case that gave India the basic structure doctrine. In the next 7 minutes, how a reclusive Kerala seer's property dispute became the biggest constitutional case in Indian history, and possibly the most important court decision this country has ever seen. After independence, India's governments pushed aggressive land reforms, abolishing zamindari, taking over estates, redistributing land. Landowners went to court, arguing the constitution guaranteed their right to property. Again and again, the Supreme Court struck down land laws for violating that right, so Parliament fought back, with amendments. In the Shankari Prasad case of 1951, the court said Parliament can amend even fundamental rights. It confirmed this in Sajjan Singh in 1965. Then came the earthquake. In Golaknath, 1967, an 11-judge bench ruled 6-5 that Parliament cannot amend fundamental rights at all. Parliament and the court were now on a collision course. Parliament's answer was a barrage of amendments. The 24th Amendment, 1971, declared that Parliament's power to amend includes fundamental rights. The 25th curtailed the right to property and compensation. The 26th abolished the privy purses of former princes, and the 29th shielded Kerala's land reform laws inside the 9th schedule, beyond judicial review. Those Kerala laws hit a small monastery in Kasaragod district, the Ednir Mutt, headed by a seer named Kesavananda Bharati. He challenged the laws in the Supreme Court, and his lawyer was the great Nani Palkhivala, perhaps the finest constitutional lawyer India has ever seen. The case landed before a bench of 13 judges, the largest in Supreme Court history, never repeated since. Arguments ran for 68 working days, from October 1972 to March 1973. Palkhivala warned, if Parliament can amend anything, a ruling party with a big majority could abolish elections, end federalism, and install a dictatorship, all perfectly constitutionally. A constitution, he argued, has a core identity that no majority may destroy. The government side countered. Parliament represents the will of the people. Unelected judges cannot chain it with invisible limits. The entire nation waited for the answer. On the 24th of April 1973, the verdict arrived. 7 judges to 6, 11 separate opinions, around 700 pages. The slimmest majority in the court's biggest case. The holding came in 2 parts. First, Parliament can amend any part of the Constitution, including fundamental rights. Golaknath was overruled. But second, and this changed everything, Parliament cannot use that power to alter or destroy the basic structure of the Constitution. Numbers in a legislature, however overwhelming, cannot rewrite India's constitutional soul. So what exactly is this basic structure? The judges deliberately refused to freeze a final list. They sketched the idea, leaving courts to work it out case by case. From their opinions emerged the pillars, the supremacy of the Constitution, a democratic, republican form of government, secularism, federalism, the separation of powers among legislature, executive and judiciary, judicial review itself, free and fair elections, the rule of law. Any amendment may reform these features, but it may not destroy them. No neat, numbered list exists anywhere in those 700 pages. Yet this idea is now the foundation of Indian constitutional law. The drama continued the very next day. Chief Justice Sikri retired, and the government broke the seniority convention, superseding the 3 senior-most judges to appoint Justice A. N. Ray as Chief Justice. All 3 superseded judges had ruled against expanding Parliament's power. Then, during the emergency in 1975, the government tried to finish the doctrine itself. Another 13-judge bench was assembled to review Kesavananda. Palkhivala rose and argued that the verdict had claimed no new power. It had merely recognized limits that are inherent in every genuine constitution. Within 2 days, the bench was dissolved, and the review attempt collapsed. The doctrine survived. Since then, the doctrine has been India's constitutional shield. Minerva Mills, 1980. The court struck down amendments claiming unlimited amending power for Parliament. S.R. Bommai, 1994. Secularism declared part of the basic structure. I.R. Coelho, 2007. Even laws parked inside the Ninth Schedule can be judicially reviewed. And the NJAC case, 2015. The 99th Amendment on judicial appointments was struck down, with basic structure at the heart of the reasoning. Courts in Bangladesh, Nepal, and Kenya have since adopted the same doctrine. Critics still grumble. An unelected court invented a veto with no textual anchor. Judicial overreach, they say. Supporters answer. It is precisely why no parliament, however mighty, can ever legally abolish Indian democracy itself. Half a century later, Kesavananda Bharati is more than a case name. It is the load-bearing beam of the Indian Republic. The seer of the Ednir Mutt got little relief for his own land, but his case gave every Indian something far larger, a court-enforced guarantee that no election, no landslide majority, no amendment can erase the core of the Constitution. If you found this explainer useful, hit like, subscribe for more landmark case breakdowns, and comment below. Which case should we decode next? Maneka Gandhi or Puttaswamy? See you soon.